Good afternoon. Good afternoon. I am Glenn Weissenberger, Dean of the College of Law, and I'd like to welcome everyone to another outstanding CIPLET program. Needless to say, I'm thrilled that Niro, Scavone, Haller, and Niro is once again sponsoring this outstanding lecture and luncheon program, and we're particularly honored to welcome Professor Peter Drahos as this year's distinguished Niro lecturer. This coming year, we will be celebrating the 10th anniversary of the establishment of CIPLET at the College of Law. And for those 10 years, the College of Law has been fortunate to be the beneficiary of CIPLET's consistent success. The benefit is that we can always count on the program's strength and its durability. These qualities are fueled by the consistent support from firms like Niro, Scavone, Haller, and Niro, and ultimately the strength of the program draws from some of the best law students nationally who come to DePaul to participate in our IP program. CIPLET is also fortunate to include some of the most renowned IP professors among our distinguished faculty, and that would include Professors Strandberg, Sog, and Bressler, and of course, the center of all this activity and success is CIPLET's founding director, Bobby Quall. Now, some of you may be wondering, where is Professor Quall today? Well, Professor Quall had every intention of being here, but called me early this morning and told me she was suffering from stomach flu, and she sends her regrets, but she also sends her greetings to everyone here. Bobby has been an extraordinary person in leading this program. Her drive and energy are inspiring and valued greatly by all of us, but especially by me. Once again, my deepest appreciation to the Niro firm and to Professor Drahos. Thank you for attending, and to introduce Professor Drahos, I will now call upon the most recent addition to the College of Law's IP faculty, Professor Matt Sog. Matt.
Thank you, Glenn. It's my great pleasure to present here today Professor Peter Drahos. Peter Drahos is the Director for the Center for Governance of Knowledge and Development and the head of the program at the Regulatory Institutions Network at the Australian National University, one of the finest universities in the Southern Hemisphere, of which I happen to be a graduate. Peter Drahos holds degrees in law, politics, and philosophy, and is published widely in both law and social science journals on a variety of topics, including contract, legal philosophy, telecommunications, intellectual property, trade negotiations, and international business regulation. Peter Drahos has worked as a consultant on international IP issues for a number of organizations, including the European Commission, Oxfam, the ASEAN Secretariat, and the UK Commission on Intellectual Property Rights. In 2004, Peter Drahos and his colleague John Braithwaite were presented with the University of Louisville Grawemeyer Award for Ideas Improving the World Order. This is sort of the intellectual equivalent of the Batman Award. Drahos and Braithwaite won this award for their book, Global Business Regulation, published by Cambridge University Press in 2000. The book is a significant contribution to our understanding of global business regulation, in particular because Drahos and Braithwaite painstakingly interviewed some 500 leaders in business, government, and non-governmental organizations involved in the passage of the Uruguay round of the GATT negotiations, which gave rise to the World Trade Organization. It's my very great pleasure to welcome Peter Drahos. Please make him welcome.
Thanks very much, Matt, for those kind words of introduction. gave me the sign to remind me of who I am. First of all, just let me thank all the people at DePaul for inviting me here. The hospitality has been very gracious, and I hope one day I have the opportunity to repay it. This is my second visit to Chicago. The first time was in 1993. It was early in 1993. I flew in very late at night, and I remember being struck by the loveliness of the lake and the lights on the city and so on. And I landed, and the next day I had an interview at Motorola. In fact, it was for the project that Matt mentioned, the project on global business regulation, and I was interviewing people at Motorola about a variety of issues relating to the setting of standards in telecommunications and so on. And amongst the topics that we covered were intellectual property rights. Back then the world seemed very different, actually. You know, the people at Motorola, for them, the intellectual property issue really was only, I would say, surprisingly to me, part of what they were thinking about it, and it didn't have the kind of prominence in their consciousness that intellectual property rights has today. And another revolution was taking place, was the revolution in the standard setting game. So things like the International Standard Setting Organisation and so on, all of these things, the value of which were, the value of these things were only just then being appreciated. So one of the features of our world is, and of course, I should also add that the TRIPS agreement was still being negotiated, so it hadn't yet been signed, and in fact the draft, in a sense, was not made public. Only some people knew what was actually in it. So I think one of the features of our world is that change seems to come upon us, or the pace of change seems to increase very quickly. So in the 13 years since I was last here, things have changed very much more, so I suspect that if I went now to Motorola, I would be getting very different stories to the stories that I got 13 years ago. So let me turn now to the topic of my talk today, which I've called Society, Social Contract and the Patent Office. Unfortunately for me, and probably for you, many of the things that I'm about to say were in a sense anticipated by the wonderful session that we had this morning. The speakers really pretty well covered almost all of the things that I had wanted to say. What I'd like to do today is to focus on the idea of the patent as a social contract, with the emphasis on social. Sometimes we think of this, and I think Jeannie said it a couple of times, we tend to think of the social contract as sort of rhetoric, something we get out of the way before we immerse ourselves in the technicalities of patent law. But today what I want to suggest is that we should really be thinking philosophically and politically about the implications of the social contract. And in particular, I think that the social contract idea is actually a very useful normative ideal when we come to think about patent law reform. So let me begin with a little bit of history, and this will be familiar to all the scholars of intellectual property, or indeed probably fans of English, the history of English law. We know from hundreds of years of case law that when the courts turn to the institution of patent law, they use the word bargain to describe the patent institution. And I quote here from Lord Justice Fletcher Moulton in a decision at the beginning of the 20th century, in which he says that the reason why the patent specification has to contain practical information on the use of the invention is because the consideration for the granting of a monopoly for 14 years is free use by the public at the end of the 14 years. Now we see this idea or this reference to consideration in a lot of English cases, And of course, as the contract scholars here would know, consideration is one of the formal elements of contract. It's what makes a contract binding. Now, it's important, I think, when thinking about this contract view of patent law, to understand that it was the English courts, not the Parliament, that shaped patent law for more than 200 years. In actual fact, there was no patent legislation passed by the Parliament from 1623, that's to say the date of the Statute of Monopolies, until 1835. And in fact, the 1835 legislation was of minor significance. It was only really towards the end of that century, in 1883, that major patent law reform took place in the United Kingdom. So in other words, the courts in the United Kingdom had more than 250 years in which to shape the evolution of patent law. And they did so using this idea of the bargain, this notion, and drew on contractual principles in order to do so. Well, one of the British, Britain was an empire, and one of the things that empires do is to spread regulatory models. In fact, those regulatory models usually last for much longer than the empire does itself. And so many countries ended up, through processes of colonisation and so on, acquiring English patent law. And of course, I would argue, along with it, they acquired this idea of the patent law as a social contract, as a bargain. And Australia is a spectacular example of that, as is New Zealand, as are many countries of the Commonwealth. And so, when I was preparing this lecture, I did a search, for example, of the Federal Court database in Australia and found many examples of the courts continuing to refer to this idea of consideration and the patent social contract. So here's just one example that of many that one could choose at random. A patent is a public instrument which grants the right to protection of a defined monopoly for the consideration of disclosure, and so on. Well, what do we as the sort of academic and scholarly community make of the idea of the patent social contract, or indeed what do practitioners make of it? It's something that we tend not to think about very much. I came across a very nice paper by Shubha Ghosh, published in the Berkeley Technology Law Journal in 2004, in which he evaluates the idea of the patent social contract. And ultimately, he concludes that it's an unhelpful metaphor, that it provides courts with too much interpretive freedom. He also suggests ultimately that the idea of the social contract links to the sort of social contract tradition of the 17th and 18th centuries, people like Locke, Montesquieu, Rousseau, and he suggests that this grand political tradition of social contract theorising has absolutely nothing to offer patent law. And his preferred approach, and I think probably the preferred approach of many people, is to develop a regulatory theory, what he calls a regulatory theory of patent law. Well, what I would like to do today is to mount something of a defence of the social contract as something that is helpful. But let me begin just by observing that it's probably true to say that the social contract philosophies of people like Rousseau and Locke and Hobbes and so on the face of it at least, might not offer much to patent law. Primarily, of course, I mean, one reason for that might be because at the time of these thinkers, patent law was not a very important institution. I mean, we only think of the modern system as evolving really in the 19th century. It's true for most of our regulatory institutions, whether we're thinking about tax or welfare administration, that it's really only in the 19th century that they emerge as recognisably modern. And in some cases only in the 20th century, an obvious example being environmental regulation. So let me suggest, or begin by suggesting that there are three reasons for why we should think that the patent social contract is useful. I think the first is that it has to do with purpose. One of my favourite jurisprudes, Lon Fuller, had a general complaint, which is a theme in many of his writings, that ultimately when we begin to refer to rules and we manipulate rules, we don't pay enough attention to purpose. And so I think one of the reasons we should take the social contract idea seriously is that actually it is part of the narrative of purpose that the courts have constructed for themselves, and they have done so for a very long time, for hundreds of years. So like it or not, this idea of the social contract is deeply embedded in our patent institution. I think there's a second reason for why the prism of contract is useful. And this has to do with a neutral starting point. Often when we think about patents, we think about property. We think of patents through the prism of property. But the perspective of property tends to place all the weight of attention, all the focus on the right holder's interests. And it carries the danger with it that the interpretive playing field might be tilted excessively in that direction. The contract perspective, I actually think, makes the interests of both parties clearer. It actually reminds us that there's a bilateral relationship. There are the interests, social interests to consider, as well as the interests of the other side, the inventor, the inventor's representative. And in this bilateral situation, it's not obvious that one should elevate necessarily one party's interests above the others. That's what I mean when I think it's a more neutral starting point. I also think that the contract perspective allows us, if we begin to investigate it, to ask questions we might not otherwise ask. For example, what is the role of the Patent Office in the context of the social contract? Well, a plausible answer might be that the Patent Office is society's agent in the process of social contracting. It solves a certain kind of collective action problem. We as society are not going to band together to try and figure out whether we should grant this patent or not. We need some degree of expertise. The Patent Office perhaps is a pool of expertise that helps us to come to some sort of decision. But then if this is right, if the Patent Office really is society's agent, how do we ensure that the Patent Office really does represent our interests? How do we deal with the problem of regulatory capture? And one of the interesting things when you look at the field of regulatory studies is that patent offices as captured institutions are very much understudied. We have decades of scholarship in regulatory capture, whether one is talking about taxation agencies, administrative agencies, environmental agencies, yet the scholarship on regulatory capture in patents is actually very, very slim. And of course, as someone said in this morning's session, or rather in the question and answer to this morning's session, perhaps we should think about whether the Patent Office indeed is the appropriate agent. Might not we contract out the business of representing society's interests to an entirely different kind of group? There's, I think, a third reason for why we might think about contract, and here I do spring or draw on the idea of the social contract tradition in the much broader sense. Today's patent law has become a major institution. In fact, as I said, in the last 13 years, its significance seems to have grown much more, even as compared to those companies that I interviewed 13 years ago for global business regulation. So what begin as simple, in the medieval times, as simple monopoly privileges, the importance of which probably were not that great, actually, out of that has evolved a genuinely global institution, one that's spread to many countries, and in which we see companies essentially using intellectual property rights now, including patents, as part of a sophisticated ordering strategy in technology markets. And we also know that this ordering has very large-scale efficiency effects as well as distributive effects. So it seems to me intuitively obvious that no such institution should escape evaluative scrutiny. That would be taking too much on faith. We would want, as citizens, to morally evaluate such an institution. And so social contract methods, as practiced by people like Hobbes and Rousseau and so on, but in particular as practiced by John Rawls and other modern representatives of the method, are actually quite a good way in which to begin that process of moral evaluation. And in part, I in particular like the approach that John Rawls uses because it forces us to think about this institution behind the veil of ignorance. You don't think about it from the position of an actor that has a particular advantage or a particular gain to have or to make from the patent system. The idea behind the veil of ignorance is that you think about the institution without knowing what possible advantages and gains you might end up making. And the whole idea behind the method then is to, as it were, avoid partiality. So that's a useful starting point then, I think, for evaluating an institution like patents. So let me just say a few brief things about disclosure, because I think that if you take the social contract idea seriously and you take what the courts say seriously about the importance of disclosure, then disclosure does seem to be at the heart of the bargain in many ways, or the bargain that the bit that society receives. The disclosure function is something that we should be thinking about. Well, I think the first thing to say is that the disclosure function varies from country to country. Essentially, because patent law is statutory, what we see is that different countries impose the different obligation of disclosure using different language, which has been interpreted by the courts. And so at a technical level, at the level of rulemaking, we see this obligation played out in lots of different ways. So here are some examples of different language. The European Patent Convention, for example, talks about disclosure which is sufficiently clear and complete. And I don't need to tell you what your section 112 says, except of course it has very different language and includes this idea of setting forth the best mode contemplated by the inventor, which is language that one doesn't see in other jurisdictions. In Australia, we talk about describing the invention fully, including the best method known to the applicant. I think Article 29 of TRIPS, which actually mandates disclosure, is interesting. What Article 29 does is it says, and it's clearly a compromise, as it were, between the European and US systems, it says that the applicant for a patent shall disclose the invention in a manner sufficiently clear and complete, so it expressly picks up the language of Article 83 of the European Patent Convention, and then adds as an optional extra, may require the applicant to indicate the best mode for carrying out the invention. Well, whatever else you think of TRIPS, it seems to me that, in a sense, it's globalised the idea of the social contract. Countries, in a way, that sign on to TRIPS are also signing on, I think, to a sort of social contract idea of patent law. Now, as will be familiar to everybody in this room, there are lots of hurdles to disclosure. We all know that there's an incentive problem, and there was some discussion of that this morning. Of course, if you're applying for a patent, you do have an incentive to withhold some information. But patent applicants may not necessarily want to cheat in any case. It just might be that the nature of the invention is inherently difficult to disclose. So we invent, or rather we come up with different kinds of ways to make disclosure possible, deposit requirements for biological organisms. Or the inventor may actually be uncertain as to what they've invented. It might be part of a complex system, and they really don't want to hang around trying to figure out exactly what it is that they've invented. They're as it were, plagued by uncertainty, but then the patent system is also part of a race. So for all sorts of reasons, disclosure is difficult. Nevertheless, I think from a social point of view, we do face two important questions. One is, how high should we make this particular standard? If we're trying to set a standard, should we aim for a higher standard or a lower standard? And then the question is, how do we police it? My own view is that if you think of the patent institution as a pro-competitive institution, if you believe that story about patents, that ultimately the purpose of the patent institution is to complement competition in some way, then disclosure does become important. A high standard of disclosure does become important in that story. Because in part what you want to do is to put in the post-patent period manufacturers in some rough position of equality. It can never be complete equality, but in some rough position of equality with respect to information. And so what you would like to see happen is a higher standard of disclosure in order to fulfil this sort of more pro-competitive operation of the patent system. Of course, information, as I said, or disclosure is never going to be perfect for all sorts of reasons. I think another question then is, well, how do we enforce the disclosure standard? And here, when we look at jurisdictions, everybody does it differently. There are different ways of enforcing disclosure. For example, in the case of under the European Patent Convention, failure to disclose is a ground of opposition. So if you have a post-grant opposition procedure, one way in which you enforce the standard is by making it a ground of opposition. In the United States, you don't yet have post-grant opposition. I was very interested in this morning's discussion to learn that it's much closer in some sort of geological timescale to fruition than outsiders like myself would appreciate. But in any case, in the context of the US system, failure to disclose can ultimately lead a defendant in an infringement action to be able to counter-sue. So you have a means of policing adequacy of disclosure even without post-grant procedure, post-grant opposition rather. So generally, I think that the social contract idea pushes us in the direction of higher standard of disclosure and taking the idea of disclosure more seriously. And so I agree with the thrust of what Jeannie said this morning, that we should, from a social contract perspective, be thinking about invigorating that standard. Let me now turn to the role of the Patent Office under the social contract idea. Because as I said, I think one of the virtues of thinking about the social contract idea is to ask, well, what role does the Patent Office play here? Well, again, as would be familiar to everybody in this room, patent offices face, as our agents in assessing whether or not to grant a patent, a profound problem of information asymmetry. Now, asymmetric information is an idea that's been important in economics for about 2 decades, 2.5 decades. And it's typically linked to cases of market failure. In fact, it was Akerlof who, in his very important paper on used cars and the market in lemons and so on, drew attention to the important effects of asymmetric information in markets. Now, he argued in relation to used cars that the inferior informational position of buyers of used cars would make them cautious about price, what they would pay for a car. And this, he argued, in turn would lead sellers of the market to leave the market so that the market would contract. In a sense, it's actually an application of Gresham's law. You know, good money drives out the bad. Rather, bad money drives out the good, so the bad cars, as it were, drive out the good cars. Well, we can see that information asymmetries also bedevil the patent examination process. We can recognise these information asymmetries with respect to two classes of information. First of all, what we think of as invention information. That's the information that the inventor has about the invention by virtue of having made it. That's information about how the invention works, how it can be made to work best, and so on. And then there's eligibility information. That's information about the eligibility of the invention for a patent. And with respect to both of these classes of information, both invention information and eligibility information, we can see that there are important information asymmetries. The examiner is always, generally speaking, will be in an inferior position with respect to both classes of information. And I think it's worth thinking about why that is the case. We know, and again this came up in this morning's talk, that invention itself is a collaborative process. In modern parlance, it's a networked process. But in a sense, that's not something that characterises the invention of today. It's always been the case that invention has been networked and collaborative, that it's been based on teams. And we know this from studies, for example, that have been done of German chemical firms in the 19th century. This team and collaborative approach was employed then. And then this team collaborative approach rapidly spread to pharmaceutical industries in the United States, for example. So in other words, this internal team approach to invention and innovation has itself evolved to become much more networked. And in fact, now what we see are clusters of networks. And since examiners are not inventors and they don't participate in these networks, it follows that they will tend to be in inferior positions when it comes to making or having invention information. So behind the lines of a patent application, there are going to be complex networks of knowledge of many individuals that really fully explains the origins of the particular invention. Now the model in most patent offices, and here I should say I'm drawing on a study that I'm currently conducting of patent offices, actually not as it happens the US PTO, because I figure there are enough people studying the US PTO. Rather, this is a study of patent offices primarily in developing countries, the large players, Brazil, India, China and so on, as well as many smaller countries, including places like Kiribati. Kiribati is a little island in the Pacific that's about to go underwater, or it will as a result of global warming in a few decades. I think the highest point on the island is about 2 metres. But it has a patent office. It's a filing cabinet in a single room, and it has 17 pharmaceutical patents. It's surprising it has any patents, really. So I'm interested in both the very small players and the large players in developing countries. So in all of the countries that I've done so far, that's about 15, the essential model of patent examination is that of the single examiner dealing with a patent application. Now, it is true that examiners do talk to each other and occasionally one finds team approaches. But I'm surprised by the extent to which team approaches do not predominate. So in other words, we're essentially comparing the knowledge of one individual against the network knowledge of applicants. So here we have radical information asymmetry. Now we also can make some social choices about what we do about this information asymmetry. The important thing is, though, that we don't really know what the effects of this information asymmetry are. There's a lot of ignorance about that. The ignorance has to do with the fact that it's quite difficult to get data on what actually the effect of patents are. And there are all sorts of complicated reasons, not complicated reasons, but it has to do with the fact that most of what happens in the patent system is a matter of private knowledge. It's a matter of private bargaining. You know, cases represent a small fraction only a small fraction of cases are litigated, and even if you look at the European system, a comparatively small number of cases are actually opposed. So whether one is looking at administrative procedures or litigation procedures, much of what happens about patents is private information. And in terms of our social science methods, getting at private information, that poses a big challenge. How does one find out, for example, that companies choose not to launch products because of patent portfolios? Well, getting at this through surveys is very difficult. We run a lot of survey work at RegNet, and getting the right person to fill in the survey is actually very, very difficult. And I was reminded of this as a result of another study I'm doing, which is the effects of free trade agreements on medicines, in which I interviewed, doing a lot of interview work in Australia, because I'm looking at the US-Australia FTA, in which we interviewed all the generic companies in Australia, which is actually is much less impressive than it sounds, because there are only 6 generic companies. So we then spread out and began looking at vitamin companies that produce vitamins and so on. And we found, for example, one company that had actually not launched a product because of a US patent. It was combining vitamin C and vitamin B and something else, and it was called, a patent in the US had issued on this, and then because of the Australian patent, the company, it was called Executive Stress, which I thought was an odd title for a vitamin thing. You know, it gives you executive stress, but in any case, the company had withdrawn the particular patent, and this had to do with having to certify various things under our therapeutic goods administration process, which are also reforms that were brought about by the FTA. So we found out about this particular withdrawal, and it struck me that had we tried a survey, chances are the survey might not have been filled in by the right person, because only a few people knew that this product had actually been withdrawn. So finding out about what doesn't happen because of patents is quite problematic. It actually requires a hell of a lot of legwork. Of course, we can consider detailed case studies, so we can go into particular areas and do a lot of detailed case studies, but then we don't know how generalisable those case studies are. So what's going to be true in one industry isn't necessarily going to be true in another. Or we might try the method of counterfactuals, you know, if X had happened, you know, this would have happened. But again, that's speculative. So the bottom line is we don't actually know much ultimately about these asymmetric effects. Now, and here I draw on the work that people like Dan Burke have done, and Lemley and so on. You know, one view is to say, well, it doesn't actually matter, right? The fact that we have these information asymmetries out there, we shouldn't. What we shouldn't be trying to do is to invest more money in the patent office itself. What we have to rely on are other institutions to take care of these possible effects that these asymmetries are producing. And so rather than invest more in the patent office itself, we should rely on institutions like litigation and so on. And again, this is a theme that's been picked up by other people like Adam Jaffe and Josh Lerner. I have read their book, Innovation and Its Discontents and so on, and that's essentially their argument as well. They say, here I quote, that most patents are worthless and unimportant. So setting a sort of Rolls-Royce standard of examination, or maybe Rolls-Royce is the wrong metaphor these days, I should be saying the Lexus standard or something like that, or whatever standard you have in America, the Cadillac standard. But anyway, in any case, investing more, as it were, in patent examination is a waste of social resources. Now, this argument itself tends to rest on certain assumptions, the most important one being that patent litigation itself works efficiently. And again, it's not clear that it does. patent litigation markets vary from industry to industry. Perhaps patent litigation in the pharmaceutical market is efficient because in America at least you have a lot of generic competitors. It's not clear to me, because of the very low numbers of players in the Australian market, that patent litigation is actually efficient at all, because you have so few generic players, and so the incentives for collusion are actually quite high. And I know from the work that I've done in Malaysia, you don't have an efficient patent litigation market in Malaysia at all. Once the patent gets on the books, it stays there, no matter how bad. And so the idea that patent litigation itself is, as it were, a safety net, there are a lot of assumptions that are subject to country assumptions and so on. I think it's also worth questioning the assumption that that many patents were worthless or useless. I think there's an error here, what the philosopher would call the error of the fallacy of composition. What's true at an individual level may not be true in aggregate. So a patent which is by itself potentially worthless or useless, when it becomes part of a patent portfolio, might have a different kind of effect. So the story here is not so much about the effect of particular individual patents, but in part it may be a story about the effect of patent portfolios. They may have sort of in aggregate deterrent effects that are not true of individual patents. So the stories that we come up with, or the analyses that we come up with, are riddled with all sorts of assumptions. So what are patent offices trying to do about information asymmetry? Well, essentially they're investing more and more money in the model of the single examiner. Essentially what we see happening is that patent offices, and this is true in Japan where I was a little earlier this year, the Japanese are hiring another 500 patent examiners in order to deal with the problem of backlogs. And most of the major patent offices that I've been to are trying to hire more and more examiners. Now the question is whether this will do much good in terms of dealing with the problem of information asymmetry. In a sense, it's a bit like what I would call a Fordist response to the problem of patent examination and information asymmetry. You're sort of on an assembly line punching out more and more patents, and so the idea to increase productivity is to, as it were, will make the people on the assembly line work a bit harder. So here's a photo I took at the USPTO of more and more patent examiners kind of working away. And so the real question is whether investing more in terms, which is what all these offices are doing, and I might say this is true for all of the major offices, whether this is worthwhile. Another way is to think about trying to reorganise the Patent Office itself in more profound ways. Here I'm draw on the idea that I think was really first, or most cogently elaborated by von Hayek. Von Hayek was very famous economist who won a Nobel Prize for his work. One of the arguments that von Hayek said, or one of the arguments that von Hayek made, was that the information needed to run an economy was really too widely dispersed throughout that economy for any kind of centralised direction of that economy to be possible. Of course, he was writing at a time when central planning was very much in vogue, both in Europe, both in Western countries, and of course, Western countries were responding to what they saw as the success of the then Russian model. And Hayek was saying ultimately that this attempt to centrally control economies would run into very deep problems. So if you take this idea seriously, the idea that centralised offices cannot cope with dispersed information, then centralising more and more functions in patent offices is actually a bad idea. And of course that's what's happened. The European Patent Office, the Japanese Patent Office and the USPTO have grown into very large bureaucracies. This was the kind of model of economic governance that Hayek was against. And it's the model of economic governance that still, in the minds of many people, is the way when we think about governance, is the way we think about it. We have the state, it has the command of law, and it essentially regulates these various different areas. So this idea of the hierarchy, as it were, as a form of governance, is something that Hayek was, as I say, essentially arguing against. Now, if you think the problem, as I said, is bad in these large offices, they're even worse in developing country offices. You know, what I'm finding is that the capacity of developing countries to examine it all is severely compromised in many ways that I don't really have time to elaborate. They don't have trained staff. They don't have access to the databases that people doing patent searches simply take for granted. In many offices, it's not even electronic. So if you go to the Philippines, you're doing a paper search in the office. And so what happens in these offices is that they essentially rely on the work of the major offices. Well, here are the patent office, the patents, as it were, coming off the line. But here's a typical decision tree. This one's based on what happens in Vietnam. So essentially what happens is the Vietnamese patent officer will look to see whether the EPO has granted the patent. And if the EPO grants the patent, then the Vietnamese patent examiner will do so. If they can't find a patent granted in Europe, then they'll look to see whether the USPTO has granted one. And if the USPTO has granted one, most times they'll also grant. And if the USPTO has refused, then chances are that the Vietnamese Patent Office will refuse. Now, I've done these little decision trees for most of the patent offices that I've been to, and it just varies. You know, some say the Malaysian Patent Office will also look to see what the Chinese Patent Office has done and so on. So very little examination actually takes place. And so the social contract idea in many of these countries is in a sense symbolic. It's like a ritual. There's nothing very much meaningful about it. Now, one tempting thing to do might be to say, look, why don't we just get rid of the social contract idea of the patent institution altogether? I mean, with these information asymmetries, the deep difficulties in trying to come up with meaningful examination, we should perhaps get rid of that as a sort of normative ideal. Think of another normative ideal if you can't make the institution work according to the normative ideal. I think that's probably the wrong way to go, because ultimately at a practical level, somebody has to make a decision about whether one is entitled to a patent or not. And so many of the practical issues that face us, irrespective of whether you think the deep origin of the patent lies in contract or in natural rights or some other theory, these practical decisions about whether to grant or not require us to think about information asymmetry. So it seems to me, irrespective of what ideal one chooses, you have to think about this issue. You might then say, well, let's rely on these other institutions. Let's weaken the Patent Office and not invest more in the Patent Office. Let's think of other ways in which to do it. But I think that would be weakening an important lever, as it were, of governance. And the trend in all modern economies is to increase levers of governance. Right? So governments around the world are not throwing away levers of governance. They're finding ways to try and increase levers of governance, whether it's through public-private partnerships or many levers. I'm not just talking about the lever of law. So the response, as it were, to challenging risk management problems of all kinds is to increase levers of governance, not decrease them. So we should stick with the Patent Office, is my view, and think about how we then might reform it. So the key problem then, in a way, is trying to figure out how, from the social contract point of view, we can utilise dispersed information to improve the performance of the Patent Office. Hayek thought ultimately that it was only the market that could do this job of bringing together what he called dispersed information. Of course, Hayek was writing at a time when we didn't have sophisticated, at his time, when sophisticated networks of information technology were not around. And so networks of information technology offer us possibilities with respect to the reform of the Patent Office that didn't exist at the time that Hayek was writing. So then what we should be thinking about is looking at ways in which to increase the Patent Office capacity to utilise knowledge. And utilising knowledge means utilising networks. That's the basic idea. Now, before I go on to say a bit more about this idea, I should say that patent reform itself, our capacity to utilise networks of information technology to reconceptualise and reconfigure the role of the Patent Office, ultimately always comes down to questions of political feasibility. That's what ultimately all questions of patent law reform come down to. And so the idea that I'm arguing for and that other people have argued for, that to make patent offices more open to the plurality of networks that are really important to assessing invention, whether that is going to happen or not will depend on politics. I think the important point that I want to make here is that patent offices are what I would call selectively open organisations. They've evolved as selectively open organisations. They have been responsive to networks of patent attorneys, to the regular corporate users that use those networks. But whether they're going to be selectively, whether they will be more open to the other kinds of networks that exist out there and which ultimately matter from a social point of view to the operation of the system is quite a political question. And I myself am not optimistic that that will happen anytime soon. So, what I want to briefly do then is to outline three basic preconditions for what I call efficient social contracting. The first one is network pluralism. And I think what patent offices have to recognise is that knowledge is going to be dispersed through a plurality of networks, and that the utilisation of that knowledge requires a patent office to find ways of utilising those networks. I think a second precondition is what I call network diversity. You have to recognise that if knowledge is dispersed through a lot of networks, those networks value, gather and decide to release information in very different ways. They have very different incentives for releasing information or making knowledge public. So network diversity, I think, is quite key. Very different incentives face different kinds of networks for the release of information. And then the third precondition is what I call nodal openness. And that's really implied by conditions 1 and 2, network pluralism and network diversity. Patent offices should be what I call open nodes of operation. That's to say places where networks cluster, where they get tied together, where patent offices try and facilitate networks releasing information. Now, I think network pluralism and network diversity are simply empirical truths about our world, like it or not. That's just a fact of life. There are too many networks clustering around any particular issue for you to count. And there's a lot of diversity out there. And we know this from countless studies. These are things that are unarguable. Nodal openness, however, is an organisational choice. One can choose to organise in that way or not. So here are examples of network diversity. Well, this is the modern, as it were, networked governance model that Hayek, in a sense, was arguing for, where the state is just but one actor, and what you actually see are public and private actors clustering around, impacting on the state impacts on them. So it's very different to the sort of hierarchical way of thinking that Hayek was so much against. Here's what I mean by network diversity. There are many kinds of different networks that are now in existence that were not in existence a couple of decades ago. And these networks are now becoming much more engaged with the patent system in ways that we never thought about previously. So the Patents on Life campaign by Greenpeace, for example. Here's another one, the Electronic Frontiers Foundation patent busting project. This comes out of India, the Mailbox project, which is a bunch of civil society NGOs in India creating a database of what's in India's patent mailbox, as well as they don't just gather this information, they also carry out pre-grant opposition. Here's another example. There are just lots and lots of these examples of network diversity, different kinds of networked actors out there. Here's another one. So the basic idea then is that we seek to try and harness these different sorts of networks. And so the Patent Office itself has to become more porous, as it were, with respect to the ability of these networks to disclose information that's relevant, say, to a patent application, to participate in the patent process itself. That's the key idea, that the more you do that, the more you encourage networks to enter the system, the more you'll move, as it were, ultimately towards more efficient social contracting. So here's an example that you'll all be familiar with, which is this community patent review project, which I think is a good example of the sort of thing that I'm talking about, the idea of using a networked approach to patent examination itself, trying to harness, as it were, networks of knowledge that are out there that can do collectively a better job of evaluating a patent application than is currently possible under this sort of single model of patent examination. So a more networked approach as opposed to the Fordist approach that I suggested characterised Patent Office operations. But I also think there are other things that one can do. And in particular, I think for some countries, while we've been talking about post-grant opposition here, I also think for some countries at least, it's very important to think about pre-grant opposition. Remember the key point here. The key point is that different actors will have different incentives to release information at different times. Now, if that's true, one should be thinking about pre-grant opposition as much as post-grant opposition. And in particular, I would say that many developing countries should be thinking about pre-grant opposition, particularly if they don't have good institutions of litigation. If litigation markets do not work well in these countries, then one should be thinking very hard about pre-grant opposition, since this is an administrative procedure which is cheaper than having to deal with a patent once it's on the books. Pre-grant opposition is turning out to be profoundly important in India. There are at least 150 pre-grant oppositions that have been launched in India. And here are just two examples at random. Now, the point about pre-grant opposition on the part of civil society actors is that they have incentives to stop the patent from getting on the books. If it's a company may choose to withhold may have information about prior art and may choose not to use it in a pre-grant opposition procedure, reasoning that it would be better to wait until they get sued. But the point is, under conditions of network diversity, there will be other actors with information out there about the patent. And they may not have commercial motivations at all. They may be driven by completely different motivations. And you will only pick this up if you have a pre-grant opposition procedure. Now, what's slightly worrying for me is that developing countries to some extent are dismantling pre-grant opposition procedures, even though I think there are very good reasons to keep it. In part, this has to do with free trade agreements. So in some free trade agreements, we find countries like Morocco, for example, agreeing not in a free trade agreement to have a pre-grant opposition procedure. That sort of seems a dangerous way in which to set limits on what one can do in the patent system. Of course, I mean, there are other examples as well. New Zealand had both, or does have, both pre-grant and post-grant opposition. And again, for small countries, that's worth thinking about. The more entry points into the system, the better. Local companies make a lot of use of these procedures. One has to think hard before you're a small country about giving up on those sorts of entry points. But we see in the New Zealand draft legislation that pre-grant opposition is going to go. So while I think there are interesting experiments out there with respect to what I call nodal openness, I like the this idea of the community review procedure, which the USPTO is going to experiment with. I also see trends going the other way, where patent offices are actually restricting themselves in terms of nodal openness, making it more difficult for different networks to participate in the system. And from the social contract point of view, that's bad. Well, I also had some other suggestions for nodal openness, which I'm just slightly conscious of the time here, which I'll take you through in a minute. So you get the idea behind nodal openness. The idea here is that one shouldn't just put all one's faith in one particular procedure, one particular way of allowing networks to participate. There are many possibilities. One thing we have to think about is getting rid of what I call insider governance in patent system. It's too cosy an arrangement. You know, big business patent attorneys driving, as it were, patent reform. The social contract idea, if we take it seriously, is much more democratic, much more open than that. I know from my own work that when patent offices act as secretariats for reviews, they tend to act as a filter. You get a lot of filtering effects. So radical ideas don't necessarily, because they have this framing power. Patent offices, when they act as secretariats, can frame reviews, agendas, and so on. So what we have to think hard about is the reform process itself. I mean, who actually gets to participate and so on. So that means we have to involve these invisible colleges or different kinds of communities of innovators much more centrally in the patent system itself. In terms of reform processes, the relevant policy committees that decide the direction in which the patent system is going to go and so on. We should And they there are real problems with the standards in this particular class. Choose particular classes. Now, there are limits to this kind of external audit procedure. The point is we need an external audit procedure, and it can be set up without any without having to reform the system. It's just a feedback mechanism. You know, it keeps the internal auditors honest, as it were. You know, someone needs to guard the guardians. That's the basic idea. I also have this idea which I came up with, which proved very unpopular with the pharmaceutical industry in Australia at the time of the Free Trade Agreement, transparency registers. You know, one of the problems that we have is finding, not just finding what the, you know, not what the patent discloses, but actually finding relevant patents. So generic companies routinely report to me the difficulties they have in finding patents and you know, because of all sorts of problems. So one idea I suggested was, well, let's have a transparency register. So say the Therapeutic Goods Administration in Australia is deciding whether or not to grant a particular application to release a particular medicine on the market. The idea is you have a register. Every patent that is relevant to that particular application has to be on that register. And if it's not, then it can't be enforced. So the incentive is if you don't disclose on the register the particular patent that you're holding that is relevant to that particular application, then you're not going to be able to enforce it against the company, the generic company who's going through. Now, so that's the incentive, as it were, to disclose. So that will then give the generic company a register on which to rely on, right? So when they're making their application, they can look at that register and say, all right, this is what we have to analyse in order to figure out whether our particular product infringes or not. So it serves an information function. It seems to me that in certain areas, regulators could do this, where it's really important to have transparency of and on the register, of course, would appear information about the ownership of the patent and so on. So where in certain areas of regulation, where we really want to have better risk assessment, you would create these transparency registers. Now you might say, well, what's to stop a company from just putting everything on there, confuse the system and so on? Well, the answer lies you would put penalties on companies for trying to game the system, for putting a lot of patents of doubtful validity on the patent, on this transparency register. And in fact, that's what's happened under the Australian approach. What we did in Australia as part of the Free Trade Agreement implementation was we created what are called anti-evergreening provisions, where companies, before they can sue another company under the Therapeutic Goods Administration in relation to a pharmaceutical product, they actually have to place a certificate, sign a certificate saying, look, you know, we've registered this patent in good faith, you know, we think it's valid, and et cetera, et cetera. And what we do for signing false certificates is attach penalties. Now, I argue that the penalties, you know, it's only $10 million, which is like nothing. It's loose change. I mean, it's a joke. I sort of said it should be $100 million, and then in another interview I said it should be $500 million, and I kind of went a bit crazy. But you get the idea that you could impose, if you wanted to, a deterrent style approach, so that companies would think very carefully about what it is they put on these transparency registers or not. So there are lots of ways in which one can create approaches to the patent system that are more sort of consistent with the idea of the social contract, that will make it work better, that will lead the social contract to have more meaning than it does currently. You know, we don't want it just to be a sort of ritual. Well, thanks very much.
So, Peter, we're going to take questions. Dan.
Peter, I want to go back to your point about Hayek and gathering dispersed information, particularly his belief that markets did that, investment markets could really do that. I mean, isn't that what we do with litigation or with post-grant opposition, is we effectively set a price to purchase an option on invalidating a patent? It's not, an option theory has a lot to do with this, right? Because you don't know
Yes.
the invalidated.
Yes.
And if that's the case, then what we're really talking about in the first panel, and maybe what you're talking about is just to get, are we going to get the right price? You know, is $10 million too high for that option? Maybe it should be $200,000. Maybe it should be $1 million.
Yeah, look, I agree with that, but the point, my point is that you have to make the patent system more porous, as it were, in terms of getting information released into the system. So post-grant is certainly important. It's one way to think about that. But there are situations, there are certain advantages to pre-grant opposition, and there are certain advantages because there's so much network diversity out there, actor diversity. So the incentives for actors to release information, which we as a society would say, well, it's desirable for this information to be released, depends in part on creating the opportunities for more release of information. So essentially, the more opportunities you create for the release of this information, which is valued subjectively differently by actors and so on, the more opportunities you create, the more information will be released. That's the sort of intuitive idea. It may not be, but I'm saying the more opportunities there
are. We'll hear from one of the students, Brad.
Quickly, you had talked about the information asymmetry between having just one examiner and on the other side, the applicant side, you've got this network group of applicants. But doesn't that get somewhat mitigated by the fact that, like, at least in the U.S. PTO, and I assume it's similar elsewhere, at least in the bigger system, they assign that particular type of patent to a specific art unit where the patent examiners are pretty much just dealing with that type of art and not expected to know everything about everything. So then they're more of an expert, a day in and day out expert. Wouldn't that kind of help mitigate the asymmetry?
Yeah, sure. I mean, that is the kind of thing where you get... But still, I would say that the difference between the networked approach of corporations and the sort of knowledge that's relevant there is always going to be of a dramatically different kind of order of knowledge to what you can do with the single examiner model. I mean, again, you have to ask how many patent examiners have doctorates, for example, in a particular area. And the only office that I've come across where that has significant numbers of doctoral examiners is the Korean Patent Office, and this has to do with the status politics of the Korean Patent Office. It's in Korea, holding a job in the bureaucracy has a lot of social status assigned to it, and so many people holding PhDs in Korea end up in the patent office. Whether that's the right way for Korea to be utilising such a highly skilled labour force is another question, but there is a large number of PhDs, so less information asymmetry.
Kathy.
Yeah, my comment is really about the sort of contractual model, and listening to what you're saying, which seems to be exactly right and brings together a lot of sort of things that I've been hearing diversely out there. I wonder if it's even correct to describe the issue with a problem of information asymmetry and a problem of disclosure, because it seems like the main point of what you're saying and what some other people are saying is that there is, of course, some information asymmetry between society and the inventor. But it seems to me that seems like that's not the main issue. The main issue is not that we need the inventor to give out more information and that there's this information asymmetry between the inventor and the society. It's that as society, we have all this information, but we just don't know, how to collect it. And so I guess I'm just saying in terms of like thinking about it from a contract point of view or an agency point of view, it's really that we had this model where the agent is the expert, so we hire an expert, hire a doctor, really maybe what you're saying is that that's not the right model for what the agent is supposed to be doing. The agent is really should be focused more on us and what we all know, unless on either the expertise of the agent or extracting more information from the inventor, which we still might want to do, but maybe that's less of the issue.
Yeah, I think that's right. I talked about disclosure because, in a sense, the social contract model, as visualised by the courts, does talk a lot about disclosure. But I agree with you that that's not the heart of the issue. The heart of the issue ultimately is, from the point of view of economic governance, and Hayek puts this so nicely, is that there is no single mind, as it were, that can have all of this knowledge, that can make the decisions for us. So he then puts his faith in markets. But the answer in part is that networks and network technology allow us, as it were, to create a network of many minds, which gets closer to not a single mind, but a sort of coordinated way of dealing with information problems. And so, and I think one of the virtues of the contract way of thinking is it begins to get at this problem of governance from this networked point of view, which I think would move us in the direction of more efficiency. One can never know, of course, but that's the theory at least.
Just referring to this slide here, just remind me a little bit about misuse of the idea of building or disclosure in seconds by reference to traditional doctrines like these.
Sure. Again, I mean, I think one should never throw away levers of governance. But the point is that because you do face so much network diversity out there, the incentives for people to use information, to disclose information, we as human beings are always making strategic calculations about when to release information. I mean, just think on a mundane level. You go to your spouse and you say, I better be careful here. Well, gee, I've been invited to this conference in Chicago, and it'll mean I'm going to be out of the house for a week. So when do you release that information? I mean, do you release that information at the point at which you come home and one of the kids, has done something terrible, and another one's sort of experimenting with setting her hair on fire or something, and the whole house is in chaos? Is that the moment at which you choose to release that information? No, you make a strategic calculation about when you announce it. So these strategic calculations are just a fact about us as human beings. And it's true for companies, it's true for the many different sorts of networks that are now all affected by the patent system. So you have to, essentially, to get that information into the system, you have to make it as porous as possible. So playing around with these traditional doctrines and so on, I think these are all good things to be thinking about, but any one lever will only do so much.
This kind of gestalt entity that you're talking about, does it really apply to predictable arts like mechanical engineering? I mean, I have a PhD in chemistry. A lot of my clients, I've got my own law firm, are mechanical engineers. And you describe that invention in a few figures. It's very straightforward interpretation. It doesn't require more than one examiner to look at it. And it's very straightforward. It's a predictable art, unlike in biotech or in chemistry. A lot of it you're relying on theories that are not fully understood, where maybe, but then you always put a catchphrase in wherever the theory is, it's not relevant to the invention.
Yeah. It's certainly true that in terms of resources and how one would use networks, one would want to be selective about the areas of technology. Or actually, that's not true. You needn't be selective. I mean, essentially, the networks would congregate around problematic areas of technology where there really was complexity. Like, for reasons I don't understand, for example, tennis racket manufacturers obtain patents. Now, it's been at least true for a decade that most people playing tennis are unable to harness the power that the modern tennis racket offers. Like, I don't want to be brutal about your game, but you'd all be better off with fry pans and better technique, So, why would, and it's dead, of course, one can just, there's no great mystery about describing racket technology or tennis string dampeners or anything else. And my prediction would be that this networked approach will not evolve with respect to tennis rackets, and we certainly don't need it to. where it would evolve would be in areas of technology where there really is uncertainty, where there are highly complex systems, where actually scientists will say, actually, we're just beginning this. We really don't know much of what's going on here.
One final question.
Yeah, I've heard a lot about disclosure today. Internationally, in the United States, we disclose, despite one of the things that I've heard, or several things I've heard. You've talked about disclosure as well as part of the social contract. What internationally, aside from the United States, are they going to, if ever, do more disclosure out of Europe or out of Asia, where you have 4-page specs, 5-page specs,
Yeah.
with 1 or 2 figures?
Yeah. Look, I don't know what they're going to do. I actually quite like the way that the US does disclosure with the best mode requirement and so on. That actually does seem consistent to me with at least the ideals that the system is meant to be representing. But here I've read accounts, I don't know whether this is true, but some people are very unhappy with the best mode requirement, and I've seen recommendations that it's too problematic in terms of litigation and that it should be scrapped and so on. So I don't know. What are you going to do about it in the US? I mean, is there that view that it's too difficult?
I don't think it's going to go away, but I have larger concerns on the international scale because our commissioner is running around globally with JPO and EPO and other alphabets with this homogenation
Yeah.
idea. But yet, when you talk about the social contract, and I hear these other professors talk about disclosure. If we homogenize, we'll probably go the other in the United States.
Yeah. Yes, I mean, that's true. The problem actually with the patent offices at the moment is these agreements that are taking place. You know, you're talking about the USPTO. The USPTO has signed a lot of memoranda of understanding and memoranda of cooperation with patent offices from other countries. The whole purpose ultimately is to draw these offices into a system whereby you only have one examination and everyone else essentially relies on it. So it's the principle of mutual recognition is going to apply. So I think there are some important issues there actually about the sorts of cooperation that are emerging amongst patent offices and what the implications of that will be for particular countries and how the social contract has worked out in those countries, and in particular for things like disclosure. I don't have any snappy answers, but it's actually a lot of this is happening very fast. I think the principle of mutual recognition as a result of these memoranda of cooperation and so on, that are the MOUs that are being signed, I think that's going to have a big impact on patent office work within the next couple of years. I think you're going to see some very important transformations, and what that will do to the profession too, I think, is going to be incredibly interesting, because once you rely on examination carried out by another office and sort of everything's very speedy, you begin to wonder exactly what value the profession's going to add. So I think there are some pretty big things happening out there which have to do with this sort of cooperation.
But that's still going on in Europe because although they give lip service to the idea of having a patent that's examined once, let's say an EPO, the ramifications of that are far from clear as you go from country to country after you go to enforce it.
Yeah, that's true. Well, that's been globalised. I think that approach is going to be globalised. So you see all those problems being magnified.
Well, I think we're going to have to wrap it up here. But Peter, thank you very much. Thank you all. And